Kia ora koutou everyone. I think we'll get started. There is still a few more people to join us, but hopefully they will join as we progress. Welcome to this webinar on data security and privacy, which forms part of our tech transformation webinar series. In this session, are some of the key issues that you need to think about in terms of data security and privacy when you are undertaking a tech transformation project. My name is Anchali Anandanayagam. I'm a partner at Hudson Gavin Martin, and I work predominantly in the technology, media and telecommunications space.
My name is Pearce. I'm a senior solicitor here at Hudson Gavin Martin with a focus on tech contracts, privacy and consumer law.
A little bit of housekeeping before we get started. You will see that you are muted for this session. But please don't let that hold you back from asking questions. There is a Q&A function at the bottom of the screen, so please do use that. Now, this session is likely to be slightly shorter than the other webinar sessions that we've included, so we will definitely have time for questions at the end. So please do ask questions should you have any, and we will get to them at the end of this session. Now, when Sarah and I were preparing for this webinar, we were discussing the extent to which data and how data is treated has changed so much over the last few years. We are now entering an age where not just organisations but individuals also fully understand the value of the data. We've all heard that expression, data is the new oil, but we think that unlike oil, the ways in which data can be used and leveraged to drive value are infinite. But with those opportunities and to take advantage of those opportunities, it's really important that you ensure that data is dealt with in a compliant way.
And this is really important, particularly when you are dealing with personal information. This is because a customer's buy-in to any product or service is largely based on trust. And so if customers don't trust the way in which you will deal with their data, then they're likely to stop giving it to you. And so the opportunities that you can unlock from data will be limited. So it's really a case of balancing trust with potential opportunities. In this webinar, we're going to take you through a life cycle of a tech transformation project and the considerations that you should bear in mind having regard to personal information, privacy and data protection. Anchali is going to take the supplier's perspective and I'm going to take the customer's perspective.
Now, to illustrate what you need to think about in terms of data security and privacy in the context of a tech transformation project, we will use the example of moving from a on-premise tech solution to a solution that's in the cloud or a SaaS-based solution with the help of an implementation partner. Now, throughout the webinar, when we talk about the implementation partner, we're referring to the implementation services provider, so the provider that will assist a customer move from one solution to the other. And when we're talking about the vendor, we're talking about the provider that will provide the SaaS solution itself. Now, in many circumstances, that could be one and the same person. So the implementation partner and the vendor could be the same entity. But for the purposes of this webinar session, we will treat them as two different entities.
And so regardless of the type of the tech transformation that you are undertaking, a critical first step is to understand the types of data involved and the obligations that attach to that data. And so this will colour the way in which you as a customer will go to market with your tech transformation project. So it's a case of assessing the types of information that you hold and the obligations attaching to it, be they contractual obligations, such as, for example, confidential obligations, or legal obligations, for example, under the Privacy Act. Anchali is going to talk shortly about the different types of data that might be involved. But once you've mapped out the data, then you will be in a position to structure your RFP process to ask for information that will enable you to compare respondents and their ability to meet your expectations with regard to your data. And also once you have an understanding of the information that you hold and the types of data that you hold, then that will enable you to clearly set out in your RFP documentation what your expectations are. So for example, you can set out clearly what your data security requirements might be and what your storage requirements might be, those kinds of things.
So I think as an implementation partner or a vendor, it's equally important to understand the nature of the data that will be involved in any transformation project that you will undertake or be involved in. The reason for that is that that will allow you to front foot any discussions around security of the solution or security of the services with the customer and build trust right from the get-go. So if, for example, you provide an HR SaaS solution to customers, you know that that solution will very likely hold personal information and confidential information of the customer. Are there ways in which, as a supplier or a vendor, as an implementation partner or a vendor, you could provide the customer with assurances in terms of the security protocols that your solution has and verification of that security? The reason why I think this is really important is, again, it puts you ahead of the game. It gives you that trusted provider status with the customer from day one. I think that in terms of the data that's actually involved in a tech transformation project, now this can be varied. So it may involve non-confidential information, but more than likely it will also involve confidential information. And in terms of confidential information, there are several buckets that sit within that a subset of data. Now, it could be financial information that you are dealing with in the project. It could be customer information. It could be business or proprietary information such as trade secrets. And finally, it could be personal information that will be involved. Now, regardless of the category of data, it's important to understand that each of them will come with their own set of obligations, whether those obligations are contractual or they are as a result of law. Now, if you think about financial data, for example, it may be that financial data that is involved is subject to regulatory obligations in relation to that data. Another good example is as lawyers, we have confidentiality and obligations, not just ethically but also legally, in terms of the client information that we hold. And so those obligations overlay any tech transformation project that we would undertake. So once you understand the nature of the data that will be involved in the project, then as a customer, it will be easier for you to then pin down the obligations that you are likely to have in respect of that data, and also to then understand what you will need to pass down to an implementation partner or a vendor in terms of security requirements and privacy requirements that will allow you as the customer to comply with your obligations. Now, from an implementation partner or vendor's perspective, understanding the nature of the data that will be involved in a project that you're involved in will help you gauge whether those obligations that the customer is seeking to pass down to you are reasonable, whether they're appropriate given the nature of the data, and therefore you can make an assessment as to whether those are acceptable to you. Now, our comments across the webinar are going to apply to all confidential information that will be involved in a tech transformation project, but we will call out particular considerations that apply to personal information as we go through.
Yeah, so in New Zealand, the key legal obligations that attach to personal data are contained in the Privacy Act. And the current law will be replaced by a new act which comes into force on the 1st of December this year. You may have heard a lot of discussion about the new act and what it might mean for your business. We are not going to go into the detail of the new act in this seminar, but what we will do is touch on some of the obligations under the Privacy Act and the impact that they might have on a tech transformation project. So as you are probably aware, there are currently 12, soon to be 13, information privacy principles that are at the core of the Privacy Act. These information privacy principles set out how organisations are to collect and use, disclose, store, transfer, and place limits on retention of personal information. A new privacy principle coming in under the new Act places limits on the disclosure of personal data outside of New Zealand. Another one of the big changes that you've probably heard about is mandatory reporting of serious data breaches to the Privacy Commissioner and to affected individuals. It is all of these principles and obligations that should be considered when embarking on a technology transformation project, and how that might affect the contracts that you put in place with service providers.
I think it's also important to bear in mind any obligations that might apply to data that you hold that come from other jurisdictions. So, for example, if you hold personal information that will be involved in the technology transformation project that is about data subjects located in the EU, then you'll need to consider whether the GDPR or the General Data Protection Regulation is going to apply to that data, and how you will ensure compliance throughout your tech transformation project. Now, you will all, I'm sure, be aware of your obligations under GDPR if you are a business that either provides goods or services to data subjects located in the EU or monitors the behaviour of data subjects in the EU. Then you will be subject to the extraterritorial application of the GDPR, and will need to take into account your obligations when you are looking at a tech transformation project that involves that subset of data.
So once you've completed your data due diligence process and you've gone out to market and selected an exceptional SaaS product and also an implementation partner who will help you with the migration, then it's about considering what detail goes into the contracts with those suppliers. We're going to start by looking at the agreement between the customer and the implementation partner, and then we'll move on to the contract with the vendor. The first thing we want to talk about is use restrictions. And so from a customer's perspective, your data is obviously hugely important to you, and in addition, you might have privacy or indeed other legal obligations in respect of that data. And so you might want to ensure, you probably do want to ensure, that the implementation partner will use your data solely for the purposes of providing you with implementation services and not for any other purpose.
So I think from an implementation partner's perspective, I would be looking for an assurance from the customer in relation to the customer data that it provides to me, or that I will have access to in order to provide the services. And that assurance will be along the lines that the customer has the rights and the consents that it requires in order to allow me to be able to access and use that data to perform my obligations. I'm also likely to look for an indemnity from the customer in relation to customer data that it provides to me. And that indemnity will be in order to protect me in the event that a third party makes a claim against me as a result of data that the customer has provided to me and which I have used in accordance with the agreement.
And so the next thing we want to touch on is security. As a customer, you will want to ensure that your data is secure, A, because it is confidential information and you won't want it to be compromised, and B, where personal information is involved, then you will have an obligation to ensure that it is protected from unauthorized use and disclosure. And in the case where you are giving your data to a third party, in this case the implementation partner, you also have an obligation to ensure that everything within your power is done to prevent it against unauthorized use and unauthorized disclosure. And so as a customer, you would be looking to impose obligations on the implementation partner to maintain security measures at least as protective of your data as your own security policies. Now, from supplier form contracts are likely to promise only reasonable security measures or perhaps adherence to industry standard security measures. And while these promises sound good in the abstract, they are still open to interpretation. And so from a customer's perspective, if you can't get your own security measures in place, then it's preferable to specify an actual independent security standard, such as an ISO standard, for example, for the implementation partner to follow and perhaps even be audited against, or at least keep it updated regularly.
So from an implementations partner's perspective, the extent to which I am going to be willing to take on a responsibility for security of data will really depend on the demarcation of responsibility between the customer, myself, and the vendor of the solution. And to understand that demarcation, I'll really want to understand the nature of the services that I provide and the environment within which I'm going to provide those services. So for example, if I am asked to be involved in data migration, I will want to understand the extent to which that migration takes or happens within the customer's environment. Does it happen within the vendor's environment? And if either of those things are correct, then I would want to ensure that my responsibility for data security is limited to the extent that I do something within those environments that creates the data loss or the security incident. And the reason why I want to be clear on demarcation is because as an implementation partner, I have very limited control or no control over the environment of a customer or a vendor. And so I would certainly want to understand my responsibility and the demarcation and where that sits.
And so in terms of liability, this is all about allocation of risk. From the customer's perspective, you would probably be looking for broad indemnification from the implementation partner for damages arising out of their failure to comply with the confidentiality obligations and security obligations. The customer would also want to carefully review any provisions that might limit the implementation partner's liability, including exclusions of consequential damages or caps on overall monetary liability. This is really important because the damages that can arise from data breaches may include a variety of losses, such as notification-related costs, which is particularly important under the new Privacy Act, legal and IT-related fees, and also reputational harm. These types of damages are typically difficult to quantify and could very well exceed the general cap on liability and fall within the usual exclusions of indirect loss. And so as a customer, ideally you'd be looking to have no exclusions or limits of the implementation partner's liability in relation to breaches of confidentiality or failure to comply with their security obligations.
But as we all know, we do not live in an ideal world. So as an implementation partner, what I would be willing to accept in terms of liability will again really depend on that demarcation of responsibility in terms of data security and protection. I am likely to push back on having an uncapped liability for a data security incident or data loss, but I may be willing to look at a different cap and what we refer to as a super cap in respect of data loss and data security incidents. Now, in terms of what that super cap looks like, generally speaking, it's a multiple of the general liability cap that sits in the agreement, or it could be a number that that the customer and I, as the implementation partner, are comfortable with in terms of a higher cap for data loss.
Yeah, so then it really becomes a question as to what is the value of that super cap. And so from the customer's perspective, we'd obviously want it to be as high as possible. But in terms of calculating what that might be, it could be helpful to consider whether as a customer you would want your implementation partner to maintain insurance, and then the value of that insurance coverage could inform the calculation of the super cap.
So we are now going to move on to the vendor arrangements, but the issues that we have discussed in respect of the implementation partner will also apply in respect of the vendor arrangement. But there are some additional considerations, we think, that will apply in respect of data security when you are looking at the vendor arrangement, which we'll take you through now.
So in addition to having adequate security measures in place with your vendor, the customer might also want a warranty that the vendor solution or the SaaS solution will be secure, and also that the customer's data and the customer's systems, if it's integrated, will also be secure. The language that you will get will largely depend on your bargaining power. Most vendors are going to balk at warranting complete security, but I think it is reasonable to ask for a warranty that the SaaS solution doesn't contain any viruses, backdoors, or other harmful code.
From a vendor's perspective, I operate a one-to-many service, and what I mean by that is that I offer one solution that is the same to all of my customers. And if a customer requires me to sign up to some bespoke obligations or bespoke security requirements, then I would struggle with that on the basis that that would mean I could no longer offer a scalable solution to all of my customers at low cost. Instead, what I might do is be able to offer you as a customer assurances around the security of my solution. As I mentioned at the start, as a supplier, I might have front-footed this discussion with you, knowing the nature of the data that is going to be involved in the project. But if I haven't, then at this point in time, I would perhaps present you with my audit report that shows I'm compliant with ISO, or my SOC 2 report that shows that I meet verified industry standard security measures. And so in that way, I would hope to get the customer across the line that my solution is secure enough to hold their data.
And so that brings us to storage. In terms of storage, it is important as a customer to understand the locations where your data will be stored or otherwise processed by your vendor. Some vendor form agreements will expressly reserve the right to store and or back up customer data in several countries around the world. And while dispersed geographical storage can be beneficial from a redundancy perspective, if personal information is involved, then it can be problematic. So for example, if your data includes personal data of EU data subjects, then depending on the locations of storage, you might need to ensure whether you need to put in place adequate onward transfer mechanisms with the vendor. Now this is because New Zealand currently has adequacy status under GDPR, and that means that personal information can be transferred from the EU to New Zealand without the need for additional safeguards in place. But any onward transfer outside of New Zealand to a location that doesn't have adequacy status will mean that you need to consider putting in place an adequate onward transfer mechanism, such as, for example, the standard contractual clauses. And this is also relevant here at home in New Zealand under the new Privacy Act, which I mentioned earlier, which will introduce a new privacy principle which places restrictions on the transfer of personal data to organisations offshore. Importantly, the new information privacy principle won't apply where you are transferring personal information to a service provider who will hold it solely and process it solely on your behalf. So it's an agency type relationship, as that won't be deemed a disclosure of the information for the purposes of the Act. But where your service provider, in this case the vendor, will use the data for their own purposes, then you need to consider whether the transfer of the location outside of New Zealand will be compliant under the Act. And so generally speaking, if an individual has authorised the disclosure, then it will be fine. But if you don't have the express authorisation of individuals, then you will need to ensure that the information will be protected by safeguards that are comparable to New Zealand's law. Examples of how you can achieve this are by imposing contractual data protection obligations on your vendor that are comparable to the protections under the new Privacy Act, or by ensuring that the vendor is subject to the laws of another jurisdiction that have comparable safeguards, so that you would be limiting storage to certain jurisdictions which have so-called adequacy status in GDPR terms.
So from a vendor's perspective, I think one of the benefits of using a one-to-many solution for my customers is that customers are able to take advantage of improvements that I make to the solution based on the experiences of other customers. And in order to do that, I will look for the ability to potentially use the way in which the customer uses my solution to improve my services. So generally speaking, I may look to use the customer's data on an aggregated or non-identified basis in order to, for example, improve my solution. And on that basis, on the basis that it is non-identifiable information, I would hope to assure the customer that this would not trigger the disclosure obligation under the the new Privacy Act. Of course, if I do want to use data for other purposes in an identifiable way, and it's personal information, I want to use it in an identifiable way, then as a vendor, I need to be aware that that may trigger that disclosure obligation for the customer, and that the customer is likely to pass down contractual obligations to me unless I'm located in an adequacy in a geography that has adequacy status. The customer is likely to pass down to me contractual obligations that ensure that my use of the data complies with the Privacy Act.
So then another important issue to turn your mind to is business continuity and data recovery, particularly now that we have COVID. As a customer, you would want to understand the processes that the vendor has in place for moving up and down alert levels, and how that might affect your ability to access your data, particularly if you receive, for example, a request from an individual for access to their data.
Again, I think from a vendor's perspective, this really depends on the nature of the SaaS solution that I will offer. So many SaaS solutions allow the customer to have access to their data at all times. So if that is the case, then I am likely to push back on any additional obligations to allow access to that data. I would also expect that the customer, because they can access the data, would have and maintain their own backups of that data.
So then looking at breach, as a customer, you would want to ensure that the vendor is contractually obligated to notify you and to take other steps in the event of an information security incident involving data that they hold. This is really important because if your confidential information is compromised, then that could cause you significant harm. But it is also really important where your data includes personal information, because under the new Privacy Act, there are mandatory notification requirements in relation to serious data breaches. Now, we're not going to go into the detail of what constitutes a serious data breach in this seminar. The obligation under the Privacy Act is to notify as soon as practicable after becoming aware that a notifiable privacy breach has occurred. And so as a customer, you might want the vendor to cooperate fully and promptly in any investigation of a security incident involving your data that they hold. You might also want to control or have some control over public announcements relating to any such breach, as your reputation can be at stake, especially if your customers know that you use this vendor to store data. And you might also look for remediation obligations to ensure that similar incidents don't happen in future.
Now, from a vendor's perspective, in terms of obligations in the event of a breach, again, as I offer a one-to-many service, I'm highly motivated to ensure that my solution is secure and that any data security incident is dealt with quickly and in a way that limits harm. And that's because, again, if there is a data security incident on my solution, it's unlikely that only one customer is affected. It's likely that many customers will be affected, and that will be harmful for my reputation and business. So I'm very motivated to get it resolved very quickly. Again, I would push back on taking on bespoke obligations to any particular customer and how I deal with a data security incident. Instead, I would offer the customer the process that I offer to all customers in respect of dealing with data security incidents. Now, given the damage that this could cause to my reputation and my business, I would also want to work relatively collaboratively with the customer in terms of going out and making public statements in relation to any data security incident. Of course, I acknowledge that there will be requirements under law that the customer will need to comply with, but outside of that, then I wouldn't be looking for the customer to, at the very least, consult with me in terms of any public announcements that are made.
And so then in terms of return and deletion, as a customer, you might want to ensure that you have the ability to require the vendor to return and delete your data or a subset of your data at any time during the term of the agreement. You would also want the vendor to return and securely destroy your data automatically on termination or expiry. You might also want to consider whether you need transition services from the vendor upon termination or expiry.
I think, again, from a vendor's perspective, this will really depend on the solution that I offer and how accessible the data is to the customer during the term of the arrangement. Now, if the data is accessible to the customer, then I would expect that the data or the customer would be responsible for obtaining the data and having access to that when they need to. In terms of transition assistance, should the customer not have access to their data, then of course I would be willing to provide transition assistance, but I would also be looking to charge for that, for those services. Now, one thing to note, as a supplier, I may have obligations to retain customer data as a matter of law, and so I would also be looking to carve out in any obligation to return or delete data that I agree to, the right to be able to maintain or keep data for as long as I need to in order to comply with those legal obligations.
So just picking up on charging for transition services, that might depend as a customer whether I'm willing to pay for those transition services. That might depend on what has caused the relationship to come to an end. So if as a customer I have terminated the agreement for cause because the SaaS solution isn't performing to standard, then I might actually expect that the vendor provides transition services to me free of charge.
So that's actually all Sarah and I had to speak to you about in terms of the data security and privacy aspects that are involved in a tech transformation project. Now we're seeing a real shift towards providing individuals with greater choice and greater control over their data. Now some examples of this are the open banking trial that's happening in New Zealand, which refers to the ability or a standardized framework for the sharing of bank customer data with trusted financial services providers like fintech companies or technology companies, for example. NB is also currently going through and considering options for establishing a consumer data right in New Zealand. Now that describes a mechanism whereby I, as a consumer, could securely choose to transfer my data that is held about me from one entity to a trusted third party, all based on my consents and what consents I grant in respect of how that data is shared. Now, with that backdrop in mind, it is really important that any organisation undertaking a tech transformation project does so in a manner that is compliant and that ensures that the trust of the customer is maintained. So just to recap, in terms of technology transformation projects and what's really important in terms of data security and privacy, the key really is to understand the nature of the data that you hold or that will be involved in the project. That then will allow you to understand the obligations that will apply to that data, and on that basis you will be able to allocate responsibility between the customer, the implementation partner, and the vendor to ensure the security of that data. So I think we have time for questions now, so we will get into those. I think we do have some questions. Let's see. No? Does anyone have any questions? Please post your questions into the channel and we will answer those for you. We'll give you a few minutes to think of your questions and post them in. Now, while we are waiting, in case there are questions, do join us next week for the next session in our Tech Transformation series. The next session will be on technology joint ventures with Sarah Jane Lawson and Andrew Nicholl. So if you are available and would be keen to hear about that, please join us. It will be at the same time next week on the same day. So it seems that we have answered all your questions in our webinar. So thank you for joining us, and I appreciate this is shorter than the time we had booked, but hopefully we gave you some food for thought. Thank you. We'll see you again.